fast forward any come more what's on you so how say GH politics avenue podcast stories at 20 make with headlines and a jumbo need to be exomo or honey young rock say and there you did can special say subscribe to the channel. It's a notification bell share now for front so inside into it and can be nominal can say a year a highway is why hot time I do it be room or a year suspended Chief Justice Gertrude Torkonoo Australia. Very well. Now the echo ebenyina say Mami Eddie Akwadan a year Ecowas Court of Justice say umo enkabimano on the area. Na a lawyer for any ekukudama omo ekambi ewomu echere say nsema mama de koye no eno enhodi water. Na omo chere say the fact that the case is happening at the local level is generally not a bar to go into the Ecowas Court of Justice. Enti kiane ke ohia next maamena semne de say a transfer o Ecowas dia probability say ibitimi abo asem atogo no enso high. We say na beja for transfer mu di honkoma at this point in time no best say yenko na yenko ti di umo so eka. Me da say wajemre e wa say
been very clear. This one is beyond argument. Maybe we are mixing it. What the ECOWAS statute says is that if you have a case before another international court, so let's say you have a case before the ECOWAS court, then you run to the African court. They say international. We can read them if there's time. No. If there's time.
We'll pull it
but
up. Yes.
As for the domestic one, so for the lawyers who are interested, if you Google it, you see this case. The registered trustees of Addo Resource Center, okay, Human and Environmental Development Agenda versus the Republic of Nigeria. Let me repeat it because lawyers, I mean, we are all giving education. It says, the registered trustees of Addo Resource Center, Human and Environmental Development Agenda versus the Republic of Nigeria. If you want, suit number ECW/CCJ/APP/40/21. Okay, and the judgment 2024. Or if you want, just Google simply. It's a case pending before a domestic court, a bar to the institution of another case in the ECOWAS court. You will see, you'll find it now. As you keep digging, you'll get the judgments. So that one, there's no argument at all. You don't even need to show that the domestic court will be unfair, they will be biased, political, that it is illusory. No, they just say it is not a bar. But maybe out of abundance of caution, you want to show why the domestic court is not one. If you like, I can read this last line, but that's extremely clear, okay, that it is not a bar. Let's not go and say something that, so listen here. It says, so the case I just read, okay, let's read. It says that the court held in registered trustees of the Socio-Economic Rights and Accountability Project, SERAP, versus the Federal Republic of Nigeria and one other. That's 2016 CCJ ELR at page 433. That where a case is lodged before the local judge under the domestic court system of a member state, there is no bar on the community court entertaining the same case.
You are absolutely right. You know, you can look at that.
Even the
case clearly tells that that's consistent with what Layamatipebo read. Now, our quick search shows that what you're saying is correct.
Yes.
That no, the fact that a case is happening at the local level is generally not a bar to go into the ECOWAS Court of Justice. That is what our search, how you just put it. In fact, I encourage our listeners to also do so.
Google.
You get it. Yes. But this is why I bring in. Let's understand the basis for Kweku Ansari's position, right? So then, if you have to bring in your point as well, Mr. Kweku Ansari is a former director of the Ghana School of Law. He's joining us on Zoom right now. But you've been listening. You hear Lawyer Martin Pebble's position about the position that you held sometime last week when I spoke to you off record. You had indicated that the ECOWAS court will take into consideration whether or not the applicant before them has exhausted all internal avenues of redress. Correct?
Well, she exhausting internal remedies simply means ensuring that the proceedings have terminated to completion. They have, gone through every step. You see, she is preventing the steps from being implemented. So she hasn't exhausted. She cannot be said or cannot be argued that she has thereby exhausted, the internal remedies. No. So merely, inundating the court with, incessant applications is no meaningful reason to suggest that she has, exhausted the internal remedies. She has been filing application upon application, and if you look at the nature of the application that have so far being usually considered by the High Court and the Supreme Court, you see that they were wholly, factually, and legally unmeritorious. And if an application is without any merit, the obvious outcome is a dismissal. It will be refused, and they have been refused. And when she launched the first one, you recall that on one of your shows, I indicated that she can file millions of applications, but insofar as Article 146 is concerned, the provisions stand guard over any such application. So you may file repeated applications. They can only create ugly noises in the courtroom, but applications ultimately become a social nuisance. Legally, they are incompetent. And for a Chief Justice, bringing application upon application and being told to their face that the applications lack merit is not good for her own image. It is not good, for the general public. It is not good for Ghana as a nation. That our Chief Justice will file an application that a committee, will assess, evaluate, and see.
All right, but then how do you see this case playing out from where you said? What outcome do you expect of this case, taking into consideration all you have just said at the ECOWAS court?
One of those, cases, I think, that be a return match. They will ask her, they will ban her to come back to Ghana. I don't see how the ECOWAS court can change our rules of procedure. Our rules of procedure are, firmly embedded in the High Court rules with the support of, the Evidence Act of 1975 and RCD 323. They are there. It is a procedure for Ghana. It is not the procedure for ECOWAS. It's for Ghana. And ECOWAS doesn't have, a West African sub-regional procedure that we are applying and violating. It is our own rules of procedure and evidence that we are applying. And therefore, taking the matter out of the purview of our court to the ECOWAS court is not going to achieve the desired, purpose. I think it will be defeated. And at the end of the day, I think that upon a sober reflection, the Chief Justice will realize that, she has shot herself wrongly in the foot. No one else. She's making her bed and she's lying in it. And it saddens and pains me that, she's adding more insults to injury. I've said elsewhere that.
Right. And And that point that you made, and this way, Mr. Conquest, I bring it. So, people, that's some detail to the position that he took, that ECOWAS court cannot necessarily change the rules of engagement, essentially, if you look at it. But then again, he still holds the view that there are a number of applications regarding this matter. And you see the Deputy Attorney General reference it as well, that some of the issues he's seeking as relief in this application are also being tried already here.
Yes.
So why not wait for the outcome before going?
Yes, so as we said, the ECOWAS court is saying they can also look at it. And don't forget that, you see, in law, as we, in human nature, we are different. Some people are conservatives, others are liberal, some are in between, etc. We should bring the psychologists. I keep saying that that's one area we don't pay attention to. Sometimes we just see human beings and we think everybody is good or everybody is bad. No, but there are differences. So in the same way, in law, there are various philosophies. So you hear the textualist approach, the purposive approach to interpreting statutes, constitutions, etc. Right? Yeah. So to that extent, a case that you may see as bad here, it's possible in the other forum they may see it as good. You say, so I don't want to say anything about the substance of her case. No, as I've said, she's struggling already, right? I mean, the torture, okay? The torture is a lot, and you see that's how come I've repeated here several times that if I had my way, I would have seen if we could have mediators come in and see how she can be allowed to exit with a resignation. Because now you see where we've been taken to ECOWAS court. So those things have been published with the ECOWAS court. Who knows, from ECOWAS court, maybe she'll go to the African court. We don't know where else. So by the time we are done, all of us would have been fully dragged in. So sometimes, I mean, if you give the person an exit, for me, what is clear is that once it's an exit to go, fine. Okay. But not an exit that come back, no. Right. No, that one I'm very, very clear that no. These are very serious matters. Either we go into the details and get merits, or she should be given an opportunity to leave, but not the one that come back and occupy the position without us going into the case. Okay. As for that one, if she wants to come back into office, then let's go into the case. Okay. Okay, because those are very serious matters. We can't sweep those under the carpet. Otherwise, democracy will not grow. So that let's be very clear. Indeed. So let's see how we can do, because now it's becoming just one too many. Today we are in this court. The next day we are in another court, and the publications, it's dragging us. It's dragging us. I don't think that it helps us. Yes, somebody say, well, maybe it's generally a taboo conversation. Perhaps if we don't get a political settlement to it, and she continues, by the time we are done, okay, we will now in future discuss these matters without feeling squeamish about them, right? They will no longer be taboos. They will no longer be a Pandora's box. Okay, that's also another thing. But if we can resolve this quickly, that will be better so that we get closure.
Thank you very much. On this, I don't intend to spend too
much. Let me, you see, this CJ matter, I think my brothers have spoken, but let me bring this perspective. There was a petition.
I beg you. I want a question answered. Okay. Before you go on. Otherwise, Martin Gebu, you have given him a question to answer, and he spent time talking about other things. You were asking whether the CJ had said that by her suspension, she had been virtually sacked. Effectively sacked. Okay. And then I was thinking you wanted Martin to speak to it, whether that is true or not. That is very important. Whether she can remain as the Chief Justice to oversee her own, trial. But that's what he has said.
He said that she's not coming back.
No, he said that in the last part of the conversation.
Unless she wins the case. No, she can't come back. Let me repeat.
Can she be the Chief Justice? Because you said that
she can't come back.
He answered that in a form.
So don't worry, let's repeat to be clearer. What I'm saying is that if we can get a settlement that she should resign, exit, go. Okay. Yes, I'm in support of that so that we can reduce the litigation because it's embarrassing us, right? But if she's not willing to take a resignation, it wants to be led back to act to continue as chief justice. No, that one is not possible.
Thank you.
It's not possible.
Please.
Yes. So let me say this. Sometime last year, late last year, Professor Azar brought a petition for the removal of the CJ. Yeah. That petition was acted upon and determined. Yeah. What did the president do? The president made the prima facie determination. President Nana Akuffo made the prima facie determination on the petition, and on the 6th day of January this year, not last year, just this year, this 2025, one of his last acts in office as the head of state of this country, actioned that petition and said it was unmeritorious.
Yeah.
So let's bring this matter into perspective. The CJ, the suspended CJ, as she is now, never applied for a copy of that petition. Not to my knowledge. She didn't go public about it. She didn't file any process. She didn't say that she needed to be heard before the president made the prima facie determination. So let me ask, was she aware that the prima facie determination will favor her? You see, when you cry for the chick, you must also think about the hawk. Was the CJ of the view that, oh, this one, it won't hurt me, so I shouldn't cry about it? Similar petition for your removal. No, there was no cry, there was no action, no public comment. But it was acted upon using the same Article 146 process. Now, another petition has come asking that it should be removed from office. The same process is being triggered. And suddenly, the whole world must come to an end. So I have a problem about her conduct in this matter. Because she thinks that now these petitions may bite her. So she must do what she's doing. I think she's abusing the court process. Oh. Please. She has handled a lot of cases. How do you say that in pursuance of a constitutional provision that matters like this, you ought to be asked to step aside? Then you make a determination that the stepping aside amounts to effective removal. You are placing your own interpretation on it. When your own court, your own colleagues makes a determination on the matter, you go to town and berate them. You berated some of us when we went to town to criticize, even when matters have been effectively determined. You think that we, even as parties, we shouldn't speak. I have a lot of cases in the court. Some have been heard, some haven't been heard. Me, when I was entering the Supreme Court, even as a party, I was searched. Is the CJ saying that when parties were entering the Supreme Court, we are not searched by policemen? I have been searched by a policewoman before, entering the Supreme Court as a party.
Touch your groin.
You understand? So she's become very petty about some of these matters. No, the Constitution says the matter must be heard in camera. Show me in the Constitution where divorce cases must be heard in camera. Not in the Constitution. But the Matrimonial Causes Act says, Parliament says, when you bring a case to court, if it's about divorce, we should go inside to the judge's chamber. Not everybody should hear it. So your children don't follow you. When you come to court, I have done cases where parents come to court with their children. When we are going to the chamber, the kids don't follow. It's only the parties. So where it's about, when the law prescribes how a thing should be done, Boyfio versus NTAC, it's only that procedure that must be followed. Some of this can be negotiated without loud talk. That, oh, yes, I agree.
Like Martin,
yes, you don't do loud talk. You can say that, oh, please, it's in camera, but you know the situation. So I want my husband to accompany me. I don't think that panel would have refused. But if you go to town, if you paint a Addo Lodge as if it's a garrison in the Governor Barracks,
Well,
where you are being tried.
Well, it's a question.
Yes.
As to whether, since the CJ's husband and her daughter are mentioned in the petition, is it not possible that they can be called in as witnesses in the pending matter? How then do we admit them in the proceedings?
Exactly my point.
Is that if she thinks she will call
If
them
she
as
intended.
witnesses, find other people in her family.
No, so these are the issues that you can see that, oh, yes,
I
even
think
though
that's
they've been
something.
referenced in the petition, you don't intend to call them. Perhaps the panel members may be pointing to that. Why? They are being referenced in the petition. You may want to rely on them as a witness. And that being the case, we may not be able to allow them. I'm also thinking aloud.
Okay.
These matters, we are not apprised of all the final facts. So the CJ should take her time. But is she assuming that should be removed willy-nilly? I think that is her mindset. Otherwise, I'll go through this matter. For all you know, I'll be exonerated.
Hey, Charlie.
No.
Yeah, you.
No. You see, there's a presumption of innocence until proven guilty. How do you assume that one petition against you was dismissed?
This one has many charges.
No.
You
You see, the multiplicity or the multitude nature of the charges do not constitute proof. That's the law.
Okay. Yeah.
You see, however plenty the charges are, do not constitute your liability. It must be established, and evidence must be led and recanted. You are the pinnacle. You are the arrowhead of our judiciary. Why are you in a state of trepidation?
Right.
One petition came, it failed.
And to wait and some of the team course or channel you so onia mamena was so jemre aha age politics avenue na da sene so bad yani dia dombi edomania ono engrem na yemfa di chisi ensign nsumo but I say wa jemre o say aha GH politics avenue.